Hi, gun people. Well, shit, this is going to be legalese, legal update, police procedures, how the court's ruling. This was like my reading material when I was working, because this makes you understand the law. This makes you understand where the court is coming. This gives you a better understanding. I mean, any cop can say, oh yeah, you got to give somebody Miranda because of that. But if they don't understand how the court reached that and how the court deems it and when's it necessary and when it isn't and what triggers it and if you don't understand all that, you're just a little drone out there because you heard it in academy, because the sergeant tells you got to do it, and you can't think for yourself. I like understanding where the courts are coming from. I like understanding the court cases, seeing how the courts reached what the conclusions that they reached. And then when I'm articulating and explaining what I did and why I did it, it makes me a better communicator. And I can put language and use the same logic that the courts have used, and that makes me a better officer. But as a civilian, if you're not a cop, understanding this will help you when you deal with the cops, because most cops are not what I call legal smart. They know what they taught in academy. They know how to open a penal code and say, what's probable cause for arrest? Probable cause to arrest somebody is a very low standard. I can arrest a freaking donut with probable cause. It's not that hard. But arresting somebody with the intent to get a conviction and looking past that, and can I convince a jury, and am I going to lose the evidence I find because I didn't follow procedure, and understanding all that when you arrest somebody, that to me is the difference between, the 5% of officers versus the 95%. So let's take a look at this. Point of view was by Alameda County. Alameda is for Oakland, California. So they have lots of crime and lots of experience, and they charge lots of serious crimes, and they have some really good experienced DAs. The guy who used to do this was Mark. Yeah, there he is, Mark Hutchins. I used to call him all the time when I got into something that I thought was iffy, or if I was writing a warrant, I go, look, man, I'm trying to do this, and I don't think I can do this because of that, but I think I can do it because of that. And he went, I think you're reaching there. I think you'd be better off if you did it for this. And we would run things across each other. So he was really a huge resource when I was dealing with technical complex cases, trying to get warrants or trying to get information that wasn't available, and figuring out a way to use the law legally and to get the information. So he's kind of like the head dude on this. The DA kind of probably just lets him do it. He makes all these decisions. She just puts her name on it to get publicity, I'm sure. But great article. If you want to go here, it's Point of View. If you just Google Point of View and Alameda County, it'll come up. And let me go back. And so when you go to their page, you can get all the past editions. You can get the current editions, fall, spring. It comes out 4 times a year. He puts out, I think. So I just got my fall edition in the mail. And I was like, oh, you know what? This has got some pretty cool stuff in it. So in this edition, it talks about investigative contacts. Remember, an investigative contact is not necessarily a detention. An investigative contact is I see you walking at night and it's, it's very hot out and you've got a big jacket. Or it's really cold out and you're wearing a short sleeve shirt. That could spark my interest to go, you know what? Something's afoot here. I'm not real sure this is normal. Well, Rick, maybe the guy was hot. Maybe he was cold. Maybe he was taking drugs. Maybe. If and buts and coconuts. I'm going to find out. And I can do that through a consensual encounter. And consensual encounters and contacts are I don't have enough to detain you. I'm just fishing. Those are the times that people ought to say, I'm leaving. I don't want to talk to you. You have to make an officer say or do something to detain you. And if you don't do that, then the courts get to decide later, and you have to defend why you felt detained, why you didn't leave, and that determines whether or not your statements can be used against you because they were voluntary, you weren't detained, or whether they were coerced because you were detained. So if you don't understand all that, and you stand around and go, oh man, I thought I was detained, and that's the only reason I talked to him. Tough shit. Court's not going to care what you thought. They're going to just care whether reasonable person taught. So we're going to talk about contacts and go over that. Protective sweeps. My down and dirty on protective sweeps. Anytime an officer's in an area that's unknown and he thinks his officer's safety is in jeopardy, he can do what's called a protective sweep to make sure nobody's going to jump out and do it. I can do a protective sweep in an alley. I can look in cars in the alley. I can look behind dumpsters. I can, if there's a door that's not locked, I can open the door and look inside the door. All under the guise or rule of protective sweep, saying, hey, I don't want to be ambushed. So if I'm in a house and I'm talking to you, I can go, you know what? I need to talk to you for a while, but is there anybody else in the house? I'm going to do a protective sweep, and I'm going to look throughout your whole house. But Rick, you need a warrant. No, you don't. If it's under protective sweeps, I don't need a warrant. I can do it for officer safety to make sure nobody comes out and ambushes me. Well, that's illegal, Rick, and if you find something, that's fruits of the poisonous tree. Well, it depends. If it's in plain sight, it's not fruits of the poisonous tree because I'm where I'm allowed to be. If I'm looking for a person and I open a door and there's 10 pounds of marijuana in the middle of the floor, that is mine and it's legally found and I didn't need a warrant. So protective sweeps, I guess, would fall under the exigency clause because, remember, to search or to seize, you need consent, a search warrant, or exigency. And protective sweeps would fall under the exigency area. Miranda Invocations, I've talked about Miranda before. Emergency cell phone pings. I'm not sure what this covers. I haven't read it yet. My guess is that if you abduct a child or if a child is stolen in a car and I know there's a phone in the car, I can get an emergency ping without a warrant under exigency that a child is in danger and I need to get it now. And if I wait to go get a warrant, the child could be dead or in another state. So I'm assuming that's what they're talking about, emergency cell phone pings, to where I can track you through your cell phone without a warrant. Shots fired detentions. Hey, when shots fired, you can pretty much detain everybody in the area. You detain them either because they're a possible witness, because they possibly have evidence, because they're fleeing. There's a lot of reasons. I mean, look, when we go in an area with shots fired, we snag everybody. Closed marijuana containers, that's a big deal, whether marijuana, smell of marijuana. Searching vehicles, crash recorders. Now, before, we didn't used to need a warrant for that. Maybe they changed it now to where you need a warrant. If I wanted to search if you were involved in an accident, I could get it. However, if you were involved in an accident and somebody died, I wouldn't get it without a warrant because I don't want to lose it. If I get it like I usually get it and it turns up something really good, I don't want to risk a murder conviction or a murder case because I took a shortcut. So usually when you're dealing with murder or high, I don't know what you want to call them, just to where somebody's facing a lot of exposure of prison time and or death, you don't want to screw around. You want to get a warrant. If you've got time to seize the area and get a warrant, seize it and get a warrant. On poo butt shit, a lot of cops will just take the draw and go, I think I can get this through exigency. If I lose it, big deal. I lose it. Not the end of the world. Rick, that's against the Fourth Amendment. You're a big jackpot. Whatever. All right. Using poll cameras. I'm not sure what they're going to do that. Used to be, you didn't need anything to put a poll camera. I can put a camera in any public place and videotape anybody I want. Maybe they changed it. So let's talk about investigative contacts because that's the first thing they talk about. And so I'm going to go through here. And as I'm reading this, I'm going to tell you why I think they're saying what they're doing and maybe give you examples that I've used or seen used and hopefully give you a clearer understanding so you can process what's going on. This is a pretty long article, so this might be a two-part. And I haven't even started yet. So here we go. Let me shrink down my screen. Okay, so this is so hopefully you guys can read it. It's a little small, and I'll have to move it around, but here we go. So, street encounters between citizens and police officers. Oh, very, very dangerous. All right, let's go here. There are probably no encounters on the streets or anywhere else that are more rich in diversity than those of daily exchanges between officers and the public. After all, they run the gamut from wholly friendly exchanges of pleasantries. I don't know where these freaking judges are hanging out. Cops aren't friendly pleasantries any damn where. They're trying to arrest your ass. To hostile confrontations of armed men involved in arrest, injuries, or loss of life. Okay, I agree with that. situations between the two. Consensual encounter, simply put, a contact occurs when an officer who lacks grounds to detain a suspect or attempt to confirm or dispel their suspicions, which means I can contact you on a gut feeling. Rick, you can't do that. The court's ruled. Yeah, you're full of crap. You don't know what you're talking about. You're repeating shit that you were told and you don't know the concept behind it. I can do whatever I want on a gut feeling. I can't use that in court and say I did it on a gut feeling because it'll be thrown out. But I can do it all day long. We're low, Rick, you can't. Okay, whatever. Freaking courtroom, freaking punks watching ass trying to figure out, thinking you know what the hell you're talking about. Let's see. Asking some questions, maybe seeking consent or search. This is going to get a little small. I'm going to open this up. If you can't read it, well, I got to do it bigger because I'm tired of moving. Okay, so we're going to read this side after this. We're still over here. Attempting to confirm or dispel their suspicion by asking some questions and maybe seeking consent for a person or his possessions or a person. So I can walk up to you with absolutely nothing but a hunch. I can walk up to you. Get ready. I'm going to say the R word. Okay? I can be a racist and walk up to a black person, or if I'm claiming that I'm black today, I can walk up and be a racist and claim I'm stopping you just because you're white and ask you if I can search you, and I have violated no laws. The courts have ruled that no matter what my intent is, it doesn't matter as long as I'm legal. So, although my intent is to be a racist, and if I'm black, I'm only going to stop white people, and if I'm white, I'm only going to stop black people, I can walk up to anybody with my intent to be racist and say, how you doing today? I'm a police officer. Do you mind if I pat you down for weapons? And you can say no, or you can say yes, because that's not a detention. Because I have no right to detain you, I have no reason to pat you down. However, if you stop and talk to me, and while I'm talking to you, I see a bulge in your front pocket that resembles the shape and form of a handgun, now I have just developed reasonable suspicion that you might be armed, and now you lose the right to tell me no and walk away. And it can happen just that quick. So, when he's talking about asking simple questions, when you talk to the cop, the only thing you are doing is exposing yourself, and you're allowing the cop to observe and evaluate and find things that he can use against you, or find things that he can articulate reasonable suspicion to where now he can detain you and you have no right to leave. Which is why when a cop comes up to you, you should say nothing and you should walk away. Because if you don't force that cop to say, stop, you're being detained, if you don't make it clear and force the cop to say that, then the burden is on you to ask, were you really detained, or did you feel detained, or when you felt detained, was it reasonable? Make law enforcement and government do their damn job. I don't want a cop coming up to me asking me what time it is so he can check my crotch out to see if he thinks that bulge is a gun or a bag of dope, and now he's developed reasonable suspicion. I don't want to talk to him. I don't want to be around them. They ain't my friends. We ain't buddies. Stay the hell away from me unless you have a warrant or you have probable cause to arrest me or detain me. I don't want to deal with you. So, let's see here. As the Supreme Court explained, even when law enforcement officers have no basis for suspecting a particular individual, they may pose questions, ask for identification, and request consent to search luggage. Not only luggage, they can request to search you, your car, your house, provided they do not induce cooperation by coercive means, meaning you're not detained. So I can ask you anything I want, and I can pose questions. Hey, is it true that you raped a girl when you were 15? Rick, you can't ask that. You have no probable cause. Well, that's because you're an idiot. I can absolutely ask that all freaking day long to anybody with no probable cause and no reasonable suspicion. If they answer me, it's their choice. And if they tell me to fuck off and walk away, it's their choice. Okay, until you are detained by government, keep your mouth shut. Don't talk to government. Nothing can come good. If I ask you what time it is and you look at your phone and give me the time, and when you open a phone, I see an app that is used for child molestation or child tracking, and now I have a right to search your phone or seize your phone or detain you to investigate because I think you might be engaged in criminal activity with children because you opened your phone to give me the time when I ask you what time it is. Don't talk to the cops. You can come here and get mad at me about this. God damn it, Rick, you're a bootleg and you know as a cop you shouldn't. I don't want to hear that shit. Look, if you're not smart enough as a citizen to know the law to hold your government accountable, then don't come crying to me about your being a victim of cops. All right. One of the peculiar things about contacts is usually pose a dilemma for both suspect and officer. For the suspect, assuming he is guilty of something, the last person on earth he wants to chat with is someone who carries handcuffs. But he also knows that his refusal to cooperate may, or maybe even hesitation to cooperate, might be interpreted as an admission of guilt. So what? I don't care what he interpreted. It's not up to the cop. I don't care if you say no and the cop goes, oh, I'm suspicious now, because that's not enough to detain you. Flight is not enough. Saying no and refusing to cooperate with the cops is not enough to detain you. I must be able to articulate why I suspect you of a crime, I think crime is afoot, and I think you're engaged. If I cannot articulate that, then it doesn't matter whether I think you're being cooperative or uncooperative. Doesn't matter if I think you're being a dick. Doesn't matter if I think you're being racist. It doesn't matter whatever I think. I can either, as a cop, a government official, I can either articulate that I have a reason to hold you against your will, or I cannot articulate it and you are free to go. But if you stay, all bets are off and your ass is mine if you make one freaking error. You're a bootleg. Shut up, freaking crybabies. All right, meanwhile, the officer knows that when his badge might provide a psychological inducement, and I've got a big problem, and the courts have ruled this, speaking of psychological inducement, there were several cases, where cops would bring in multiple cops in an interview room with one guy. And we would basically, and I say we, just speaking as general as what cops do. I never did this. I think the most people I've had in a room was maybe me, my partner, and then maybe the supervisor would walk in 3. And even that's a little bit of an unfair advantage. That's a little bit intimidating. But the courts have ruled, as long as it's not 3 people attacking and cornering and invading his space and backing him in a corner and aggressively questioning him, 3 people in a room may or may not be perceived as coercive. If the suspect is kicking back and he's saying, fuck you cops are full of shit and I got this, and he's talking relaxed, then he can't claim that he was intimidated by the 3 cops. If he's already nervous and scared, and when the 3rd cop comes in, he backs against the wall and he looks back down and he goes, please don't beat me, I'm sorry. Man, I don't really want to talk, but there's 3 of you, and if you want me to, I will. Now, it can be coercive. That's why I'm always saying totality of circumstance. That's why these idiots that get out here on the internet who have never done this and start giving legal advice and start telling you what you can and can't do and start telling you they know the law. And if you listen to them, you're going to be okay because they know the law. Well, you're an idiot. I mean, I don't even tell you to listen to me. I'm telling you, I know what's probably going to happen, how it's going to play out, and I'm pretty familiar with the system, and I can give you good things to consider, but you need to make that decision because you have to live with the consequences. All right. And as you can tell, this is going to lead me on a lot of rabbit holes, but I think it's important you understand how all this ties together. Even one topic, that's why the people that come here and go, cops are stupid, and, somebody that cuts hair has to have 2 years of college, and a cop has 6 months. Look, cop has 6 months cab to give you basic knowledge. If you're out there doing real police work, working large cases and good cases, you are not the 6-month academy graduate California Highway Patrol that goes out there and writes freaking tickets and inspects trucks all day. Okay? That is not the cop that I'm talking about when you need to understand the law, because it gets a tangled web when you get into court, and defense attorneys and appeals courts and the Supreme Court and this case and that case and what district you're in and who your appeals court is and who the DA, and does he protect you, and does he want to fight it and does he not want to fight it, and who's the defense attorney and who's got the best lawyers, who's got the team of lawyers. All that shit comes into play, and if the cop don't know what he's doing, they're going to eat him up. There we go. Let's see. Contacts. Both officer suspect playing roles. Yes. They both know it. For the officers, acting skills, resourcefulness is not enough. Has one court put it, they must also have been carefully schooled in a certain legal rules so as to prevent contacts from inadvertently becoming illegal de facto detentions. Where this happens, where cops make a mistake, is I start a consensual encounter. I walk up to you and go, hey, dude, what's going on, man? It's kind of chilly tonight. And you go, man, fuck the police. I'm leaving. And you start walking away. And then I start walking with you. And I'm like, dude, man, why you want to be like that? I just want to talk to you. Why can't we be friends? Shut up, motherfucker. Quit following me. Yo, man, why? And now you reach in your pocket and you light up a cigarette. And as you reach in your pocket, I see a bulge that looks like it might be a bag of marijuana, or I smell a whiff of marijuana, or I think you might have a marijuana cigarette, or when you reach, you did it aggressively because you were pissed off, and I thought you were going for a weapon, so I had to grab your hand and stop you to make sure you weren't pulling out a weapon, and now I have to pat you down for officer safety to make sure you weren't reaching for a weapon. If you weren't reaching for a weapon, then we can go back to talking. But when I grab you, you pull away, and now you're resisting arrest, and now I'm more fearful, and I have to grab you because you're resisting arrest, and now I think you are going for a gun, and obviously your behavior is uncooperative, and you could be a threat to me. And now we're in a fight, and now you hit me, and now I'm assaulted, and I'm a police officer out there trying to do my job. I broke up my little quiet night of eating my donuts to talk to you, and now I'm in a fight for my life. And now you get arrested, and now when I search you, I find that you had drugs in your shoe, not in your pocket. Guess what? I get to keep the drugs because you resisted, because my fear was reasonable, because I had no reason to talk to you, but your actions and behavior develop reasonable suspicion for me to advance to a detention in order to protect myself and other officers because I was in fear of my safety. You see how easy it is for a cop that knows what he's doing to use the law, and everything I just did was absolutely 100% legal. Now, if I didn't smell marijuana and I just said that, then that's wrong. If I didn't see a bulge and I just said that, then that's wrong. But it's very easy to see bulges in things and people when they're reaching and moving and being uncooperative when I'm just trying to talk to you to raise my suspicion, which is why you shouldn't talk to government. All right, let's see. De facto detentions. Now, an inadvertently de facto detention is I say, how's it going? And you go, man, I don't want to talk to you. And I step in front of you and block your path. Dude, man, all I want to do is talk to you. Why do you want to treat me like that? And when you try to go around me, I move in front of your path again. And I go, dude, I'm just trying to talk to you, man. Come on, cut me a break. I'm trying to develop community relations here. I'm trying to get over the tension between you kind citizens and us officers. I'm reaching out to you. Come on, dude. And you try to move around me again, and I move in front of you. Okay, the courts are going to rule, absolutely, that's a detention. This guy tried to leave 3 times, and you blocked his path, even though you didn't say you're detained, even though you didn't say you're not free to leave. That's a de facto detention. Things like that can stop people. If you go to get in your car and say, I'm leaving, and I put my hand on the door, and I go, whoa, 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 don't be opening the door. I'm concerned. There might be something in there. That's a de facto detention. I stopped you. De facto detentions happen when cops do something that would make a reasonable person believe they are not free to leave and their freedom of movement has been restricted and he has moved basically under the color of authority. Okay, that's my definition of de facto detention. These lawyers in this book is going to describe it differently. Let's see, develop reasonable suspicion of probable cause. That's what I need for detention. The purpose of this article is to explain these rules. Before going further, it should be noted that whenever an officer interact with anyone in their official capacity, the law will classify that interaction as an arrest, a detention, or a contact. That's important because as a citizen, if you don't know the difference between these 3, how the hell are you supposed to make decisions on what you can and can't do? If you think you're detained or if you think you're arrested when in fact the officer is just contacting you, then you screwed up. Not the officer. Doesn't matter if you think you're arrested or detained. You have to show that a reasonable person would have felt that. And that's not so easy to do sometimes. Totality of circumstances. Arrest and detentions are 4th Amendment seizures. 4th Amendment protects you from unreasonable seizures. An arrest or detention is a seizure of the body. When I stop you from moving, I am seizing you. which means the subject has several restrictions. Officers must have probable cause or reasonable suspicion to violate the Fourth Amendment. I have to have reasonable suspicion or probable cause. Doesn't say the citizen must know that the officer has reasonable suspicion of a thing. It says the officer must have. Contacts, on the other hand, are not seizures. So, long as they remain consensual, what's consensual? It means that you're not objecting. It means that you're not trying to leave. It's meaning that you're cooperating, that you're being a good citizen and talking to me. It means that you did not invoke your Fourth Amendment to unreasonable search and seizure and say, if I'm not detained, I'm leaving. I do not want to answer questions. Am I free to go? I don't even like asking, am I free to go? Because when the officer says, yeah, he can kind of say, well, of course you're free to go, but all I'm trying to, and he can kind of sucker you into listening to him. I don't like asking. I like to say, I'm leaving. No, you can't leave. Boom. Now you're good. He just invoked a detention or an arrest. When the officer says you can't leave, you made him invoke to where there's no guessing anymore. The courts don't have to say, well, I'm not sure if the officer detained him. Yes, he did. The guy said, I'm leaving, and the cop said, no, you cannot leave. That's a detention. He has stopped your free movement. If you don't understand that, and I see these First Amendment auditors, and look, I think they're doing a great job. I think they're educating people, and they're holding cops and government accountable. So I got no problem with them. I don't think they ought to have to be an asshole and be a jerk and try to, make it into a big deal. But I think filming and making cops abide by the law is a good thing. But they have to know what a detention and an arrest is. And they have to know when they're detained. And they have to know that they don't do things that can give an officer reasonable suspicion to detain them. And now they are lawfully detained. And they're stuck. I'm freedom of the press. I'm just out here videotaping. You can't detain me. Well, yeah, you can. There's other things and other reasons that they can come up with. And I'm not going to go on all of them because it's just, all of this is a big, it can be huge topics. I mean, look at this. 30 minutes. And I covered one page of this document. And I don't know how many pages is in this episode. Let's see how many. Looks like 24 pages. So I just 30 minutes talked about kind of one page. And this article, just this topic, which is a very brief topic on this. It doesn't cover all the examples by no means, but it gives some. One of the things, officers will sometimes contact suspects in their homes. These are known as knock and talks. Let me explain what a knock and talk is from just a basic thing. I'll walk up to your house, I'll knock on your door. You answer the door and go, hello, officer. Why the hell are you on my property without a warrant? And I go, there was a robbery or a burglary in the area, and I just wanted to protect you and come here and let you know that we're looking for a suspect, and I get you to start talking. So now you stand in your doorway, and we're talking. That is called a knock and talk. And as long as you stand in that door and talk to me, it is a knock and talk. You are not detained. Because I will always say he could have shut the door anytime he wanted and stopped the conversation. The fact that he continued to talk to me and tell me I was a worthless piece of shit, no good cop, and all cops should die, and you're going to videotape me, and you're going to be on YouTube, and I'm going to get you. The whole time he was doing that, he could have shut the door. And, I mean, he couldn't know that his dumbass roommate who was under the influence would have stumbled by with a crack pipe in his hand. And when I saw that, now I have a crime in progress and I can seize that evidence because it's in plain sight. Now I can knock him out of the way and I can go in his house without a warrant. He didn't know that, but he should have known. He could have shut the door. Look, people, talking to the cops will never do it. I'm telling you. I mean, it's just, and I did a lot of things I'm talking about because I was dealing with dumbass crankers, dumbass drug users, dumbass crooks that thought they knew the system, that thought they were sharp. And you know what? Most of the time, I outsmarted them. A few times, they outsmarted me. That's okay. That was the fun part. Kind of like the Coyote and the Roadrunner. Here we go. Oh shit. Am I at 30 minutes? Yeah, I'm pretty much at 30 minutes. I'm at 29:30. All right. We'll make a part 2 on this if you want to come back, and we'll keep on going.